of Now This and The Appeal. Today, we are joined by law professors Leah Lippman, Melissa Murray, and Kate Shaw, the hosts of the Strict Scrutiny podcast, a podcast covering the Supreme Court, as well as, of course, Chris Geidner, Senior Advisor for Law and Policy at the Justice Collaborative. Wow, it's never a dull year at the Supreme Court. This year was no exception. A number of important cases came down, questions about abortion rights, LGBTQ rights, Dreamers, the ACA's contraceptive mandate, tribal rights, and, of course, Trump's taxes. Now, the term is over, but major developments continue that could shape the court and this country for years to come. First, the federal government resumed executing people this summer. Nearly 2 decades after the last execution in 2003, 3 people were killed by this government within 1 week in July, as faith leaders and activists and even elected officials spoke out against the practice and called for abolition of the federal death penalty. Second, last week, the Supreme Court rolled back Florida's monumental enfranchisement of people with felony convictions through an amendment to its constitution. Now, the Supreme Court overruled the lower court's decision and held that Florida could enforce a law barring people from voting if they still owed court-imposed fines and fees associated with their convictions. In other words, if you can't pay your debt, you can't vote. It's penalizing people for their inability to pay. Now, because incarceration frequently forces people who have served time into debt, the order of the court is going to prevent thousands of Floridians from voting. This is the latest in a series of blows dealt to voting rights by the Roberts Court, from gutting the Voting Rights Act to this term's decisions disenfranchising millions of people. Finally, the court announced last week that Justice Ruth Bader Ginsburg's cancer has returned, and she's undergone medical treatment for that, as well as a couple of other complications in the last couple of weeks. Senate Majority Leader Mitch McConnell has said that the Republicans would fill a vacant seat despite preventing the Obama administration from filling a vacancy after Justice Antonin Scalia's death 4 years earlier. The future of this court hangs in the balance. And even if Democrats win this November and Ginsburg retires in 2021, the judiciary is now stacked with Trump-appointed federal judges. Federal courts may well take center stage in the election season, just as they did last cycle. Lots to talk about. Leah, I'd like to start with you. So Justice Ginsburg, she's long been the subject of health-related questions. And yet, as we all know, she's like a beast in the gym. She's a workaholic. She's amazing. So how much is the future of the judiciary relying on Justice Ginsburg right now and her ongoing good health and resilience? What's at stake?
So 2016 was a bad election to lose by way of the Supreme Court. 2020 would be a worse election to lose. Let's think about if Justice Ginsburg was not on the court for this past term. What would that have meant? It would have meant that the court would have upheld the Louisiana admitting privileges requirement on abortion providers, thus closing 2 out of the 3 remaining clinics in the state. It would have meant that the court upheld the Trump administration's rescission of the Deferred Action for Childhood Arrivals program. Justice Ginsburg was in the 5-4 majorities in both of those cases. It also would have meant that the court held that Congress and the states, through largely conquest and terror, disestablished the Native American reservation in McGirt versus Oklahoma. So those 3 decisions at a minimum would have changed. So too could have 2 very momentous stay votes. So earlier this term, the Supreme Court did not allow the Trump administration to enforce one set of its asylum restrictions that would have prohibited people from applying for asylum if they did not enter through ports of entry. If Justice Ginsburg was no longer in the majority, that vote could have changed as well. Similarly, the court upheld by 5-4 order of the lower court allowing California to enforce its shelter-in-place restrictions against a religious liberty challenge. So again, if Justice Ginsburg was not on the court, it's possible that the court would have overturned decisions allowing the California's public health response to the coronavirus pandemic. In other cases, it's a little bit more difficult to assess what might have happened. But I think it's possible that if Justice Ginsburg was not on the court, at least one, if not both, of the president's tax return cases could have turned out differently. In Trump versus Vance, which involved the New York grand jury DA's subpoena against the president's financial records, President Trump's two appointees actually would have adopted the Solicitor General's argument that the New York grand jury and DA had to make a heightened showing of need for the president's financial records, and Justice Thomas and Justice Alito also would have adopted that. And so with Justice Ginsburg no longer in the majority, then the outcome in that case could have changed as well. And moving the median justice could affect an untold number of other cases as well. So it's difficult to understate the importance of the federal courts and the Supreme Court to the 2020 election. Again, even though the 2016 election itself was quite momentous as far as the composition and effects of the federal courts.
Wow, thank you for walking us through each of those cases where Ginsburg's role was such a big influence. Chris, I want to turn to you. In the middle of all this, the court allowed the federal government to take a 2-decade step backwards on the death penalty. This is over the repeated dissent of the more liberal justices. And this also meant resuming federal executions at a sort of striking rate this summer. So what happened? And what does it tell us about how the justices are thinking about the death penalty, the use of which has been across the board in decline in recent years?
Yeah, thank you, Emily. So glad. Just want to also welcome all of our friends at Strict Scrutiny to the briefing and the appeal. It's so exciting to have all of their great work with us. So really glad to have them here today. Unfortunately, now the bad side, I had to at least get something that was positive in, because everything I'm about to say is really bad. I mean, unfortunately, the federal executions, and particularly the way that the court handled it, was sort of like bad on every level. It was bad on a substantive level. It was bad on a procedural level. It was bad on a visuals level, which is interesting considering like all of the concerns in other areas where the Chief Justice has sort of pushed towards supporting institutional integrity. The Justice Department announced that it was going to be putting in place a new protocol, even though there had been a moratorium effectively on federal executions because there was no death penalty protocol, no execution protocol. And as they did that, they also put in place dates for upcoming executions. Those got held off for a while, but they put these executions on the books for this July and one in August. And as the process went forward, a lot of other states, as COVID-19 sort of took over, just like put off executions. The Ohio governor has already, Mike DeWine, Republican, has already put off executions through to the end of the year because of coronavirus. However, Bill Barr did not want to stop. The Bureau of Prisons did not want to stop. And these cases, as they do in any execution, got to the court toward the end, and lower courts actually wanted to keep them on hold in lots of places because of the fact that there was so much up in the air. This was a new protocol. There were questions about the process that was in place. In one of the cases, there was actually a claim that had been supported by lower courts that there needed to be more investigation into whether the individual was even competent to be executed, Perkey. And yet what happened in both of the first two executions is that after 2 a.m., the Supreme Court in a 5-4 ruling got rid of lower court stays and allowed the executions to go forward. The Bureau of Prisons executed people at 8 a.m. the next morning, even though the death warrant had been for the day before. And there were some questions about whether that's even legal. And in both cases, you had Justice Breyer, who for the past 5 years has been talking about the fact that the court should revisit the question of the constitutionality of the death penalty. And referencing back to what Leah said, he has been joined in those questions by Justice Ginsburg, but then also Justice Sotomayor and Justice Kagan both voiced dissent. Justice Sotomayor wrote writing. And I think it is interesting because Justices Breyer, Ginsburg, and Sotomayor have been sort of out front on these death penalty questions, but Justice Kagan has sort of held back more. And I think the sort of short-circuiting of the process that was involved here sort of did draw out her sort of fundamental questions about the way that John Roberts was effectively, with his fifth vote, allowing these executions to go forward.
It's so striking to think about the sort of trajectory that we've seen with the death penalty in this country and the shock at where we are right now. Thank you for taking us through that, Chris. Kate Shaw, I would like to turn to you, and I'd like to talk about Florida. Justice Sotomayor's dissent in the Florida voting rights case talks about the fact that in Florida, thousands of people will not be able to vote simply because they are poor. That's what the Supreme Court's order has resulted in Florida. And this was not the first time or even the second time that the court took a similar partisan division action relating to voting this term. So even relating to voting in the midst of a pandemic, are there legal avenues available to progressive advocates working to expand voting rights, or is the Roberts Court just gonna shut it all down?
Yeah. I mean, look, the Florida example, and just in case people don't remember the history here, in 2018, the voters of Florida amended the state constitution, right, to eliminate this extremely broad disenfranchisement law that had been on the books in Florida for many years. And so it would have restored the right to vote for individuals with felony convictions. But despite that kind of broad public support for reenfranchisement, the state legislature and the Supreme Court of the state have interpreted the amendment to condition the restoration of voting rights on the payment of these fines and fees. And a group of individuals filed a lawsuit, and a district court, after a very careful review of the allegations, concluded that this basically pay to vote scheme that was a result of this interpretation of the reenfranchisement amendment violated a bunch of different provisions of the federal constitution: the Equal Protection Clause, the Due Process Clause, the prohibition on poll taxes. And the procedural history is complicated, but basically the 11th Circuit just a few weeks ago put that very careful district court order on hold with no explanation. And the Supreme Court refused to lift the 11th Circuit order, essentially leaving in place the 11th Circuit's unreasoned stay of the careful district court opinion. And the numbers are very, the numbers could be close to 1 million individuals unable to vote both in the August primary and potentially, depending on the progress of the litigation, in the November election. So the stakes are just monumental, both individually and obviously given the centrality of Florida in a lot of recent presidential election cycles. And the Supreme Court has a big hand in that. So I think in some ways there's a very optimistic story in terms of the ability to kind of mobilize public support for progressive movement on voting. Just the fact that the Constitution was amended this way at all, which I think was an incredible mobilization and organizing feat, but also that there are gatekeepers, and significantly the federal courts, that can thwart the implementation of those kinds of changes. And you're right, this was not an isolated incident at the Supreme Court. We had two cases specifically about modest expansions of the right to vote by absentee ballot in light of these pandemic conditions. In both cases, you had district courts that carefully looked at these allegations. And in light of local election officials not taking the sort of necessary steps to protect the constitutional right to vote, ordered some expansions of absentee voting. And in both cases, the Supreme Court put those expansions on hold. And so I do think there are reasons to be very concerned about the court's track record on voting rights. And it's, Chris mentioned the sort of Roberts kind of selective seeming commitment to institutional legitimacy. I think it's right that that is a big narrative of the term, that he did care a great deal about institutional legitimacy, and there is some support for it, but there are these real gaps, that institutional legitimacy is advanced, I think, by the court not just issuing 5-4 decisions. That's one kind of institutional legitimacy, but the protection of the right to vote so that democracy itself can function should be kind of central to our assessment of the court's institutional legitimacy. And so far, I think historically, but especially in recent months, it has fallen short.
Yeah, I want to sort of go back to the fact that what we're talking about here is, the impact of the Florida decision, but also so much of the legal ideas underlying the progressive case against disenfranchisement on the basis of poverty came through in a dissent. So I want to talk for a moment with Melissa Murray about the power of dissents here. Melissa, you have talked a lot about the power of individual dissents to inject legal ideas into the public conversation. Justice Thomas having done this quite a bit from the right, but can you talk with us about the kind of dissents we should be looking for that could expand our public discussion of the law or provide new ways of looking at these concepts from the liberal wing of the court?
Dissent can serve lots of different purposes. Some of them more longitudinal, some of them more short-term. Longitudinally, dissents can form the basis for a new majority well into the future. And we saw this very famously with Justice John Marshall Harlan's dissent in Plessy versus Ferguson becoming the basis of the majority opinion in Brown versus Board of Education. But more recently, and in a more short-term way, we've really seen the power of dissents to, one, invite other branches to act. So we saw this famously with Justice Ginsburg's dissent in Goodyear versus Ledbetter, which prompted Congress to pass the Lilly Ledbetter Fair Pay Act. We've also seen it just recently in the last term with Justice Kagan's dissent in the Rucho versus Common Cause case, which was really not about inviting Congress, but about inviting state legislatures to really take the lead on dealing with partisan gerrymandering. We've also seen a lot of efforts, and Justice Ginsburg perhaps is the most striking in this. In reading her dissents from the bench, she really understands this to be a process of engaging with the public in a really direct way. And Justice Sotomayor, I think, has also done that to great effect. And we saw a lot of that this term. They didn't really have a lot of opportunities to read dissents from the bench, but we did see dissents becoming very public. So for example, Justice Sotomayor's dissent in the DACA case really put front and center the way in which the court had really dropped the whole question of the equal protection violation that might have been at the center of that case and her desire to keep that issue alive. We've also seen dissents, though, go the other way. And so, again, dissents can work for progressive ends. They can also work against them. In this term, we saw a very angry Justice Alito dissenting in the Bostock case. That was the Title VII case. And again, it was a striking dissent, striking in its anger, striking in its length and breadth, but one that was intended, I think, to galvanize public opinion on the right against these decisions. So they can serve lots of different purposes, legislative, government action, but I think primarily the way they've worked in more recent years is to galvanize the public and to localize public concern around particular issues.
Thank you for that. All right, we're going to shift gears here and we're going to go into a panel segment, which means that all of these questions are up for grabs. Anyone can take them. Treat your mute button as a buzzer and feel free to just jump in on these. Okay, so Chief Justice John Roberts. We've talked about this before on our special strict scrutiny, the appeal, now this crossover segments. But let's talk about how he's going to play into the future of the court. Will he be a centrist savior to the liberal wing, or are we just looking at a very different country that, we haven't seen before?
No, he is not going to be a centrist savior of the court. Look, I don't particularly want to live in a world in which Chief Justice John Roberts is the median justice on the Supreme Court, but I sure as fuck don't want to live in a world in which Justice Brett Kavanaugh, Sam Alito, Neil Gorsuch, or Justice Thomas is the new median justice on the Supreme Court, which is, the world in which we might be living in if President Trump is reelected in 2020. Justice Ginsburg can try to reassure us all she wants with her letter, which the letter described her diagnosis of cancer and the additional treatment she was seeking for it, and in some ways channeled the recent Taylor Swift album, I'm doing good, I'm on some new shit. But she's had cancer twice in the last year. She is 87 years old. The next term is going to last until 2024. And it's not even clear that Chief Justice John Roberts is going to be all that centrist or institutionalist on many different issues or in non-election years, and in years in which the public attention is not so much on the Supreme Court. So again, even granting that the Chief Justice is occasionally an institutionalist in some cases, in small ways, in election years when there's public attention on the court, it could just get so much worse.
I think that that's 100% right. I think that like what we've got this year and what we had, I mean, like what we saw last year with some of Justice Kavanaugh's rulings, like there is the Trump era has created such a weird position for, I mean, like what we talked about previously, like so many of the Chief Justice's rulings that are effectively wins for liberal positions are really losses for the Trump administration more than they're wins for liberal positions. They're basically saying, wow, you guys have a lot of power and you manage to go outside of that. So like even with a lot of those rulings that are leading to those claims, they're not actually long-term progressive wins. They were short-term progressive, like holding back against the gates. So I think the looking forward, I think the biggest concern really does come down to the makeup of the court. Like there's only so much he's going to be willing to do, and that we're going to see that, for better or worse, in rulings like these death penalty cases, in these voting right cases, and certainly, I mean, like we haven't talked at all basically about like corporate interests. Like he's not a swing vote there, so.
Well, the fact that we're talking about him as a moderate also suggests how directly and systematically progressives have been pummeled in the court. I mean, this is really about, as Kate said on a prior episode of Strict Scrutiny, dodging bullets. It's really not about notching wins. And if John Roberts is at the center of the court, that really is an indication not of his moderation, but about how far the court has drifted to the right.
Yeah, that's a great point. I want to also touch on something that I think we've heard a couple of times in these answers and that Chris just said, which is what's happening, this drift that we're talking about is in many ways, I think some have said, a product of the anti-democratic nature of the Senate. Because states with fewer people get the same number of senators, the Republican majority has 15 million fewer actual voters than the Democratic minority, which is a problem that's also reflected in the Electoral College. So what would you do to change the structure of the court to be more democratically reflective in, the framework that we have mandated by our Constitution?
Well, look, by design, it is not directly democratically accountable. But to return to something that Leah mentioned, the partisan gerrymandering case from last term. So just to it is, you're of course right, Emily, about the Senate and the Electoral College, but it is also the case that the Supreme Court gave permission last year for state legislatures to draw districts so that even the House is not directly democratic in the way that it should be. So the one body that in our, so it is possible right now to get more votes for your party, to get more votes nationwide for president, for in the Senate by quite a lot, in the House, and yet control not a single one of those bodies because of both the design of the Senate, the design of the Electoral College, and the problem of the distortion of partisan gerrymandering on the composition of the House. So, so I think that was actually a somewhat under the radar decision last term, but hugely significant for kind of democratic legitimacy. And Melissa was right to point out, I think that, Justice Kagan in dissent in that case did point the way to state legislatures and state courts to find ways to potentially disallow extreme partisan gerrymanders, but at least unless and until the court changes, the Supreme Court and the federal courts aren't going to do anything on that front at all. But it is the kind of thing that there can be organizing at the state level around. But I also just think that, that the court, I do think Roberts does care about the public perception of the court. It's not the only thing he cares about, and Leah may well be right that it is, an opportunistic interest in that, and that in an election year in which the Supreme Court has been, kind of in the crosshairs in some debates, court packing and other kinds of structural reform kind of issues, maybe he cares more now than at any other point. But if that's the case, I think he needs to have the message sent loud and clear that protecting democracy is the way to achieve institutional legitimacy, and it is not a side issue. And just because these cases arise on what's called the shadow docket, and so they don't get as much public attention, doesn't mean they aren't a central feature of the narrative of the court and its legitimacy. And I think if that could land in some fashion, there might be more attention and interest in how the court appears in those cases. And of course, there could well be very significant election cases around things like absentee voting between now and November. And, the court could well be in a Bush versus Gore position again in the next few months, either before the election or in the context of counting between November, December.
Well, that's something harrowing to think about for the next few months. So something to dread for the fall. We all want to know what our fall dread might be. And I'm glad that you threw out some options. Yeah, you'd mentioned state courts, and this isn't totally on that because this is more about just the lower courts and the makeup of the lower courts more generally. But how does the appointment of more than 200 judges from the Trump administration play into this? Because even if the Supreme Court does not get any more conservative, many cases aren't going to reach the Supreme Court at all because they're getting decided by these lower courts that have this influx of Trump judges. So will there be progressive legislation and any government actions at the local, state, or federal level that's going to have a more difficult time surviving the judiciary? And what have you seen on that?